Welcome to Resilience and Resolve with Lance Drury.
This is Resilience and Resolve. I'm Evan Mack with tax attorney Lance Drury. Today we're covering IRS relief programs and when collections are paused, what they really mean, and whether temporary relief is enough. Welcome back, Lance Drury, my man. What's going on?
How you doing, Evan? It's great to be back here.
I'm great. How was your 4th of July?
It was good. It was good. It was a little sad. I had somebody unexpectedly passed away, and I had somebody else I found out had pancreatic cancer. But I have to tell you, that's the problem of living in a small town you grew up in. The older you get, it's every week, but that's just part of the deal. You got to learn to go with it.
That's profound, actually. Before we get things started, and right off the bat, can you talk to the people at home about what current IRS relief programs exist that pause collections, if that's a thing?
Well, there's not any formal program on that, but there are a few ways to pause collection actions. One is you can call up the IRS, tell them that you're going to pay the amount in full in 6 months. They generally do that all the time if you tell them that. And then in the meantime, that buys you time to get your ducks in a row so you can see what your ability to pay is and to work out some type of payment agreement with the IRS before the expiration of the 6 months. Now, obviously, if you're threatened with a levy, you can either file a collection due process hearing or an equivalency hearing. And if it comes from a revenue officer, it will pause collections if you file a collection due process hearing. But a revenue officer is not going to pause collections if you file an equivalency hearing. However, if you're in the automated tax system, which is the lower liability cases, the IRS, by policy, not by statute or law, will pause collections if you file an equivalency hearing. And that will buy you time because those hearings are going to take a minimum of 6 months or more. Then you have the right to appeal to tax court if you do the collection due process hearing, which buys you more time. The difference is you file a collection due process hearing, it doesn't pause the statute or toll the statute on collections. Well, it does pause that. However, if you do an equivalency hearing, it doesn't pause it. So if you're getting close, let's say less than 2 years to when the IRS has the ability to collect, then you probably want to file an equivalency hearing because for 6 to 9 months or more, the IRS, that clock keeps ticking. That's less time than at the end of that, even if you can't get an agreement to work out before the IRS can no longer collect against you.
So, Lance, who qualifies for these programs? How do they apply, if so?
Well, for the 6 month pause, anybody can do that. You don't need, There's no real qualification for that. However, you can only file a collection due process hearing request or an equivalency request if the IRS has sent you a final notice of intent to levy. So it's only when a levy is imminent. You can't request that, if you haven't been threatened with a levy yet or anything. And you wouldn't want to do that anyway.
Do interest and penalties continue during this process at all?
Yes. You are still going to have failure to pay penalties and interest because the IRS considers this a loan. And so they're going to charge interest. They're going to charge penalties for failure to pay. The good thing is, if you never pay the full amount back, that's like getting the interest and the penalties kicked and hopefully some of the principal. But Evan, I got to tell you, it's really bad, the penalties that the IRS, they're just exorbitant. The failure to file penalty is 25% of the raw tax. It's 5% a month, but it maxes out at 25%.
Ooh.
The failure to pay penalty and the interest are about 3% or more at a time. They're tied to the prime rate, the interest rate is. But, Evan, if you and I charged interest like the IRS does, we'd be in the federal clink.
let's keep out of the federal penitentiary. You know what I mean? I couldn't.
I want to stay out of the. Although I'd much rather go to a federal pen than a state pen.
No, listen. Yeah, if I had a choice to go with jail, I'm going to.
We
Let's
had to
go
have a
federal.
choice. Yeah, let's go federal.
Wait, but are these processes automatic, or must you request this to happen?
Yeah, you have to request it. They're not going to pause it on their own. But now, of course, during the pandemic, they said that they weren't going to go after or issue any new levies. So that was sort of a pause there, which is why my business was slow later in 2020, because that's when people call me or any other practitioner, is when they're getting threatened with having their bank accounts wiped out, or 90% of their take home taken, or 100% of their 1099s. And so that still continues. And so it's when the IRS initiates those actions, that's when they come after people, and people call us.
What about financial hardships? What do those qualify for IRS consideration? You know what I mean? What's considered a financial hardship for the IRS?
Well, you have to prove to the IRS that your client doesn't have the ability to pay it back. And I can't just call them up and say, "Hey, I'm Monty Hall, let's make a deal." Or call them up and say, "Joe Blow's a great guy, let's make a deal. Let's just put him into uncollectible for a while."
Listen, Lance, for the younger audience, you got to tell people who Monty Hall is. You got to let them know who that is. You got to give them like another analogy.
There was a show in my former life, probably in the 1960s, that was called Let's Make a Deal. And the moderator of the program, the host of the program, was a guy called Monty Hall.
He was awesome.
And so that's where I derive. Most of your crowd is too young to remember Monty Hall, but there are reruns. So.
He was great, man. Yeah, watch the reruns. Monty Hall he's an all-timer.
But anyway, it's a lot of work. It's a lot of work for us. It's a lot of work for the taxpayer, because we have to prove to the IRS that the client is in a financial hardship if you come after them. So we have to go through financial statements, and they're not our financial statement. We can't just submit anything. There's a form the IRS uses. We have to adhere to that form. We have to submit that form, and we got to make sure it's accurate, because the taxpayer is submitting that under penalties of perjury. And then we also, if you're going to exceed what's called the national standards, and the national standards is for different categories of expenses, the IRS compiles a number. For example, housing and utilities. Every county in the United States is a different number based upon the number of people in the household. And if you exceed that, and most people do, you have to prove to the IRS that your expenses are in excess of the national standards. Submit the documentation, credit card statements, bank statements, debit card statements, that type of thing, cash receipts, in order to show the IRS that your actual expenses exceed that. Now, most of the time, if you have a revenue officer, they're not going to let you exceed that no matter what. The one category they might is if you've got a lot of excessive medical expenses, then you might persuade a revenue officer to exceed that. But that's one of the problems in having a revenue officer instead of the automated collection systems. There's a lot stricter formulation because they're higher dollar cases. If they want more information than the automated collection system. And guess what? If you don't get them to them in a few weeks, they have a deadline. They're going to wipe out your bank account. They're going to take 90% of your take home. They're going to take 100% of your 1099s.
So how long can this relief last? What happens when it ends?
Well, if you file a collection due process hearing, it ends after the hearing. Plus you have X amount of days. It's I think it's 60 days to file in U.S. tax court. And then if you don't file in U.S. tax court, it goes back to the automated collection system from the settlement officer. And that can take a few months because they're so far behind. So sometimes you can get a year taken off. And I got to tell you one recently. I got a guy in 2 months, $90,000. All his liability is going to fall off.
Wow.
So when he finally got an LT, and he was currently non-collectible before, we submitted it, but we never got managerial approval. So we wrote out the clock. Well, then he finally got a final notice of intent to levy, but we were so close to the collection statute expiring that we didn't file a collection due process hearing request. We filed an equivalency hearing request. And in this case, and I'm finding this out from my attorneys when I monitor their cases and talk to them about their cases, they are changing appeals officers all the time. And this guy had 3 appeals officers. So by the time the hearing was hit, the case isn't even back in collections yet. So there's no way in a month and a half's time that the IRS is going to be able to collect $90,000.
Can the relief protect against levies or even liens?
Normally, a lien wouldn't be filed at that stage.
Okay.
But that's what, if you file the hearing request for a collection due process hearing or equivalency hearing, they do protect against the levy, and the IRS will not have the ability to levy during that entire process while it's still pending. Once a determination has been made, then it's when it gets back to collections with an equivalency. If you file a collection due process, you still have the option of going to U.S. tax court, which could stop the levy for several more months.
What are the dangers of relying on temporary relief without long-term plans, if any? Any pitfalls that they should worry about?
Well, I guess the only thing is if you do that and you have the ability to pay the whole amount back, guess what? You're going to have additional monies to pay back because the penalties and the interest are going to continue to accrue. And since they're so high, you could be paying off the full amount much higher 6 months to a year later than if you just paid it off now. So that's the biggest pitfall.
So when should someone shift from waiting to actively resolving their debt? Is this when they just have it right away? They should just take care of it. But is there a moment? Is there a moment where they can wait without having this much problem?
Well, I think the biggest thing is we need to see the history, what they owe, when the collection statute runs out, and what their ability to pay is. So obviously, if we have somebody that has uh, a huge debt, but they make a lot of money, let's say $500,000 a year, we know if we call them up, they're going to have to pay every dollar. So we're inclined to run out the statute and delay the case. We're doing that right now. We have a guy in Tennessee owed $500,000 after he hires us and he paid us all this money. We found out he makes $500,000 a year. Well, last September, well over 100,000 fell off the books, and now they've got about 18 months to go before the remainder falls off. So there's probably no way they're ever going to come close to getting the full amount back.
Lance Drury, sir, it's a pleasure as always.
Pleasure seeing you, Evan. Always good talking to you.
Good talking to you as well. Temporary relief is not a permanent fix. If you need a long-term IRS strategy, visit lancedrurylaw.com and let's plan your next step. Make sure you like, subscribe, leave a review for all this good information. If you want to hear some more, you know where to find us. Thank you so much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.